Dear listener, welcome back to the Lawyer Talk, the podcast channel of BLawyers Vietnam. I am Anh Thu and joining me today is Quang Thai. We are very happy to see everyone again in today's podcast. In today's post, we will explore an important aspect in mergers and acquisitions transactions in technology companies, that is due diligence of intellectual property. Due diligence not only helps determine the value of intellectual property and intellectual property rights, but also detect potential risks. This is especially important in technology companies, where intellectual property often accounts for a large part of the value of the business.
Hi guys, I'm Quang Thai and I'm very pleased to join you again in today's podcast. I hope today's topic will help our dear listeners understand better the importance of intellectual properties due diligence in merger and acquisition transactions in Vietnam. Through our sharing, you will grasp the issue to note when implementing this process. Before sharing specific note when perform due diligence of intellectual properties, I think it is necessary to clarify that due diligence of intellectual properties in merger and acquisitions can be performed in any business that owns intellectual properties. But as Thu has mentioned above, technology companies are often businesses with intellectual properties that account for a large part of the value of the business. Therefore, in the context of this podcast, we would like to share this note when conducting merger and acquisition transactions in technology companies.
Since the scope of the note, as Mr. Hai stated, will be within technology company, I think the first question that needs to be clarified in this topic is what intellectual properties are usually owned by technology companies so that due diligence can be conducted in mergers and acquisitions. Can Mr. Hai share with the audience?
Firstly, it should be noted that the intellectual properties is not specifically regulated under Vietnamese law on intellectual properties, but Vietnamese law only stipulates that intellectual property rights are the right of organizations and individuals to intellectual properties, such as copyright, right related to copyright, industrial property rights, and right to plant varieties. On that basis, an intellectual property is identified as the subject of intellectual property rights, and depending on specific right of the intellectual property rights, the intellectual property will have different types, and technology companies will often own type of intellectual properties such as patent, industrial design, semiconductor integrated circuit layout design or layout design for short, trademark, computer program, data collection, trade name, and trade secret.
I also agree with Mr. Hai sharing some example of intellectual property mentioned by Mr. Hai and currently held by technology company include Vingroup granted or patents for methods of locating objects using a camera system, industrial design for Apple iPhone screen, and online mobile service. Joint stock company hold the trademark Momo, etc. Based on the type of intellectual property that Mr. Hai have just presented. It can be determined that the technology companies are the subject of two types of intellectual properties, right? First is copyright for work related or owned by the organization or intellectual, such as a computer program or data collection. Second, industrial property right for patent, industrial design, layout design, trademark, trade name, and trade secret created or owned by the enterprise.
I find the intellectual properties of Vingroup, Apple, or online mobile service joint stock company that Thu just gave are very intuitive example. However, I think that through those examples, the listeners will wonder how technologies companies establish their intellectual property rights for these properties, or whether intellectual property rights are automatically established for their creators. Thu, can you give an answer for this?
In my opinion, the answer is a little more complicated. As I have discussed, technology companies are often the subject of two types of intellectual property rights, copyright and industrial property rights. However, the basis for establishing intellectual property rights for each type of intellectual property has its own differences. Firstly, for intellectual property such as patents, industrial design, layout design, and trademark, and the industrial property rights of the intellectual property are established on the basis of decisions on granting protection issued by competent authority in accordance with registration procedure specified in law on intellectual property or on the basis of recognized international registration granted according with the international agreement to which Vietnam is signatory. Second, computer program and data collection are considered copyright works in the form literary works according to provision of amended Law on Intellectual Property 2023. Copyright for computer program and data collection arrives at the moment the work is created and fixed in the certain material form, irrespective of its content, quality, form, mode, and language, and irrespective of whether or not such works have been published or registered. However, amended law on intellectual property 2023 to stimulate copyright registration, so that competent state agency can record information about author, work, and copyright owners.
In my opinion, the basis for establishing intellectual property rights over the intellectual properties mentioned by Thu share a common feature. The amended law on intellectual property 2023 stipulates the procedure for registering intellectual property rights for these properties. This helps technology companies register and assure their intellectual property rights for their assets. However, in addition to the type of intellectual properties that need to be registered as Thu has presented, I see that there are some type of intellectual properties that, according to the amended law on intellectual property 2023, cannot or not required to be registered to establish intellectual property rights. So next, I will continue to spot and present in detail this type of intellectual properties. First is famous trademark. According to the amended law on intellectual property 2023, industrial property rights for famous trademark are established on the basis of their uses instead of registration. Accordingly, to be recognized as a famous trademark, a trademark must meet the valuation criteria specified in Article 75 of the amended law on intellectual property 2023. However, up to now, the National Office of Intellectual Properties of Vietnam had not issued any list of trademarks recognized as famous trademark, but only relies on the provision on evaluation criteria that I just mentioned to consider each case. Therefore, in reality, technology companies often carry out the procedures for registering intellectual property rights for trademark to ensure the intellectual property right for this type of intellectual properties. Regarding trade names, the amended law on intellectual property 2023 does not stipulate registration procedure. Accordingly, industrial property rights to trade name are established on the basis of legal use of that trade name. To ensure protection, the trade name must satisfy the protection condition and be distinct as prescribed in Article 76 and Article 78 of the amended law on intellectual property 2023. Similar to the trade names, the industrial property right to trade secret are established on the basis of the legally obtained the trade secret and keeping it confidential. Accordingly, trade secrets are protected if they are meet the condition specific in the Article 84 of the amended law on intellectual property 2023.
According to Mr. Hai sharing, I see that the famous trademark in cases are not registered as trademark, together with the trade name and trade secret, are all intellectual property that cannot be registered. Therefore, the due diligence of the intellectual property requires an assessment of their compliance with the conditions and criteria for protection under Emanated Law on Intellectual Property 2023. Only when they fully meet the criteria required by law can they are considered intellectual property. In addition, because the intellectual property right of the intellectual property does not address from the registration procedure, technology company also need to consider and evaluate how the company itself manage and secure this type of assets. At the time of intellectual property that I mentioned earlier, technology company need to check the implementation of registration procedures to ensure there are a passage for intellectual property rights. Even for computer program and data collection, I think that copyright registration procedure should be carried out. This will have technology company that are granted a certificate of copyright registration should not bear the burden of proving such copyright of the work, computer program as well as data collection belonging to them in the case of a dispute.
Based on the content that Thư and I have just shared, I would like to share some notable points that businesses and investors should consider to evaluate a target technology company, or I shall call it a target company, when participating in a merge and acquisition transaction. Firstly, it is necessary to examine the patents, utility solution patents, certificate of trademark registration for good or service, industrial design patent, certificate of layout design registration of semiconductor integrated circuits, and any international intellectual property protection title owned by the target company. It is important to verify the legal status, the mortgage incumbrance history, ownership history, expiration date, if any, scope of protection, and industrial property right associated with the formidable assets. Second, it is necessary to review and check the copyright registration status for the computer program, data collection, and the list of copyright registration certificate for computer program data collection owned by the target company. Third, identify any dispute involved intellectual properties owned or used by the target company. And finally, review the list of trade secrets, including the basis of the information of the trade secret and the measure necessary to protect those trade secrets of the target company and confidentiality agreement.
Thank you, Mr. Thai, for summarizing for our audience. Dear listener, we have passed the halfway point of the notes related to intellectual property due diligence in merger and acquisition. I hope the bold information will bring you a lot of useful information. Because the duration of podcast is limited, Mr. Thai and I will see you again in the next episode so that we can continue discussing the importances of intellectual property due diligence in merger and acquisition for technology company. And that is show the end of today's podcast. If you have any question or concern, please leave the comment below. Or for more information about BLawyers Vietnam, please visit our website below the podcast screen. Goodbye and see you again.
Thank you for listening. Goodbye and see you again.